to 19 accused persons. Mr. Peter Wanyama.
We are together with him. I think it's just a job. Wangila is
Mr. Edward Wangila.
Yes, that's my name.
Ms. Catherine Wangamati. Issue retrial directions which will govern the process.
The reason is...
Slower, Mr. Wanyama.
Yes.
Of course, watch it, man. You know the rule.
Yes.
Slow.
Your Honor, the reason is only one. We have written to the Ethics and Anti-Corruption Commission, actually 2 correspondence. That is 2 letters. Requesting for the documents to be served to us. Yesterday, my colleague from the office visited EACC headquarters to follow up on the documentation pursuant to our letter of 3rd September 2025, which we acknowledged. To our letter of 3rd September 2025, which they acknowledged the receipt. The purpose of yesterday's visit was to collect the bundle of documents. The documents which the state intends to use. Already your colleague, now Senior Principal Magistrate Zipporah Mishana, ordered that we be supplied with immediately during the date of the plea taking. Your Honor, the outcome of that visit is that EACC informed us that they are not ready to supply the documents. So, Your Honor, the reason why we are seeking for the adjournment is that we will need the documents so that we have an indication on the caseload. The number of witnesses they intend to call.
May I interject?
Yeah.
Some of the issues we're worried about.
My request, Your Honor, was that documentation that the EACC is supposed to give us so that we can address you on 1 or 2 issues in the pre-trial directions. That is really the reason why. And
perhaps you come after what I deliver.
Okay.
Address issues where you think possibly you can. Because delivering pre-trial directions does not mean end of the month.
Okay, that's okay, Your Honor. We can come in after.
And at this point, I will invite parties to raise any issues, including now Mr. Peter Wanyama, if there are any issues which can come after.
To fully comply with those orders. Important.
Slower.
Oh, sorry. Yes. 1 to 8,
then
12 to 19 to know who will be the lead counsel. And that is the counsel we intend to supply the prosecution bundle. Equally important to know who the lead counsel is, because I note that there are several counsel representing accused 9 to 11. 9 to 11. So that again, this is the counsel we intend to supply the evidentiary material bundle to, and again, who will sign the inventory that will be filed in court. Further, Your Honor, we intend to supply the evidentiary materials within a period of 30 days. I would like also to know from the lead counsel for the accused persons whether we can serve them in hard copy or soft copy. That is important so that from here we know how then to prepare the bundle. If it is hard copy, we then proceed immediately and comply with your order requiring us to serialize those documents. That will be all on our part.
Taking to comply with the entire contour of the direction we will issue.
Oh, sorry, I forgot something. Share. These are informal copies. If you require, you are taking to the directions. Continue, Mr. Wanyama.
Yeah. Thank you, Your Honor, for the copy. I'm just making the statement that we intend to comply fully with these directions. My Lord, Your Honor, just to point out one or two issues. Your Honor, the nature of documentation that EACC serves accused persons is often quite voluminous. Your Honor, that may have an impact. Usually it has an impact, and the former Chief Justice Maraga once raised this issue. It has an impact then on the trial itself, especially on the question of time.
The speed or complexity.
Yes. The voluminous nature of documentations will definitely have an impact on the time. So I took your note. I took your remarks that the issue of time, controlling the time that the defense needs in cross-examination, that will be affected then with the level of documentation. But I took your note regarding the flexibility of that trial direction. I am saying that because of Article 50, Paragraph 2 of the Constitution, Paragraph 2C, which talks about the rights of accused persons, and the question there is adequate time. Secondly, but even on that question, we will cross the bridge, I believe, when we reach there. It is not, but from the prior directions, he talked about some flexibility, where there is need to control time. But Your Honor, I will be urging that you don't control time. I am seeing the storm, Your Honor. Already from the time that the state intends to take to supply documents, 30 days, that could be quite a number of documentation. Your Honor, secondly, this we can agree with the DPP, whereas Your Honor, whereas there are 19 accused persons in the charge sheet, and noting the obligation of the state in Article 50, which talks about every accused person has the right to be supplied with documentation. Every accused person. In this case, ordinarily, it is all the 18 accused persons to be supplied with all these 30, all these heavy documentation within 30 days. Against that background, we can agree with the defense, with the state, that they supply us with only 7 copies. 7 copies of the bundle. And Your Honor, that will cover the clients that we represent. So 7 copies, and Your Honor, we have seen an excuse, a slight excuse, where they say they want to supply us with a soft copy. Your Honor, we insist on hard copies. That notion that soft copies can be supplied, they actually contravene the right to fair trial in Article 50, which talks about being supplied with documents. And then, in the context of time and facilities to prepare. And secondly, it's also important to emphasize that in your own directions, it's about a bound copy. So a bound copy necessarily indicates that it ought to be a physical copy. So let the state not create those excuses. Your Honor, administratively, I will coordinate with the EACC on the picking of the physical copies of the documents and sign for them on behalf of my colleagues. Your Honor, 30 days is really on the higher side. Nonetheless, Your Honor, we are the ones being prosecuted. So we will sit back and wait for the 30 days to be given these documents. But Your Honor, on that question, we just wanted to get the exact date so they don't create, we don't go there and they say we don't have documents. So Your Honor, we need some definitive date to be set where we'll go and collect these documents at either the Odpp or EACC. Your Honor, I think that will be all, because I think there is an order here on Direction 13 that your directions are not cast in stone. If there are any emerging issues, we will move the court in accordance with the substantive directions. And Your Honor, we also understand the sub-judice rule, and also direction number 12. And Your Honor, direction number 7, we also note, because I handled once a prosecution, an anti-corruption case, where it is actually necessary to raise an evidential objection before waiting for the production. Yeah, but Your Honor, I understand your sentiment that is not cast in stone. You will be looking at each case on its own merit. Your Honor, usually the reason here is that it can be prejudicial to the accused person. So we just request that EACC and DPP, they put their house in order so that we don't raise evidential objections, especially before the witness finishes the examination in chief. The other issues that I wanted to say are not related to pre-trial, but that is all in respect to pre-trial. Just to highlight the court that we have another application with notice of motion which we have filed, and we wanted to request that you give indications whether you will hear that notice of motion application together with another application for substitution of securities. That is all we want.
This unit, just first on housekeeping, we know setting a big
Highly projected.
self-explanatory and fair.
What is true?
The bundles for the accused, the counsel representing accused 9 to 11.
2 for.
2 for them, 7 for the first batch.
Lead counsel. You want his lead counsel. On 31st October 2025, at exactly 9, to confirm compliance and for further directions of the court, including fixing hearing dates.